and KPFB in Berkeley and KFCF in Fresno, where the time now is about 30 seconds after 12 o'clock. It's time now to have a listen to The FBI Takes Aim, a devastating account of the FBI's involvement in the trials resulting from Wounded Knee.
Here today is Jack Schwartz. He's been with the American Indian Movement as a lawyer for the past 3 years, and he's worked with the American Indian Movement for the past 5 years, the first 2 years organizing support groups. And today he's here with us, and he's going to talk about the FBI's continuing interest in the American Indian Movement, and we'll just go from there. Can you bring us up on some of the history of what the FBI has been doing in regard to the American Indian Movement?
Yeah, thank you for having me here and giving me the opportunity to explain what's been going on around the country. I imagine that people here have an idea of what the American Indian Movement is, and also an idea of what the FBI is or has been doing. More and more of the truth about the FBI, exposing it as the largest organized criminal organization in the world, has been coming out in the newspapers, even here. And it has to be put into a perspective of what happens when you have two forces, the FBI and the American Indian Movement, coming at each other at totally opposite purposes. The last trial I did was in Los Angeles County in California, which was the Paul Skyhorse, Richard Mohawk trial. People may have heard about it out here. I'm not sure if we got that much publicity. Usually when we win cases, we don't get much press. It's only our losses that get slapped across the newspapers. The Skyhorse Mohawk trial was the longest criminal trial in Southern California history. The trial itself lasted for 14 months. It was a first-degree murder with special circumstances, was the specific charge. That means that the victim was tortured to death. It's a death penalty case in California under the old punishment laws. The pre-trial hearings and motions lasted for 2.5 years. And during the entire period, the case lasted almost 4 years in its entirety. Skyhorse and Mohawk were in prison, most of the time in solitary confinement, under conditions which even Amnesty International eventually adopted them not as convicted people, because they were not convicted, and in fact we did win that case, but because of their the conditions of their incarceration were so horrible. The Skyhorse Mohawk case was a state trial, was not done by a U.S. attorney, and therefore on the face of it the FBI had nothing to do with the case at all. It was tried by the Ventura County District Attorney, which is the county just north of Los Angeles County. The District Attorney's case, which took about 9 months and about 52 witnesses, was basically that Skyhorse and Mohawk and 3 other people who were living in a rural area of Los Angeles County killed a white man, a white cab driver, in October of 1974. The cab driver's name was George Aird, and he was beaten, stabbed a number of times, and viciously murdered. The government forces that came into the crime scene, the sheriff's departments, the police departments, and what have you, within 6 or 8 hours of the murder, found 3 people there. These 3 people's names were Holly Brassard, Marvin Redshirt, and Marcy Eaglestaff. These 3 individuals were arrested, charged with murder, as they stood over the dead man. They were covered with blood, they had knives, they had the murder weapons in their possession, they had the victim's personal effects in their pockets, his cards, his ID, his trip sheet, his car keys. And an interesting thing happened. There were at least 6 FBI agents on the scene of the crime in a non-federal case on non-federal land. Therefore, they had no legal jurisdiction for being there. Now, we tie that in with the fact that within 10 days of the murder, the 3 people caught at the scene of the crime are given immunity, are set free, and Skyhorse and Mohawk are arrested in Phoenix, Arizona, charged with first-degree murder, extradited back to Los Angeles, and thrown in jail. The 3 actual murderers were given immunity in return for their testimony against Skyhorse and Mohawk. Now, that might be interpreted as just bad judgment by a district attorney, by a prosecutorial staff. To be fair to his side of the case, Skyhorse and Mohawk were at the area of the murder when it occurred. There were 6 people there that evening. But as the facts come out, it was obvious that Skyhorse and Mohawk had absolutely nothing to do with killing the cab driver. In fact, did not know that a person was being killed at all. Well, during the years of the pretrial motions, we set about trying to figure out why 2 people that there was no evidence against, no fingerprints, no hair samples, no skin samples, no blood samples, and only one eyewitness, who was Red Shirt, the man who was found standing over the dead man and covered with blood, why the state would go to the trouble of spending $1.8 million on a case which, as far as the jury told us after the case, they could not win, where there was never any doubt in the jury's mind that Skyhorse and Mohawk were being framed for some reason. My particular task in that trial was to try to explain why the inconsistencies of evidence occurred, and our analysis was because the FBI was involved in manipulating the prosecutor in order to get the only 2 activists involved in any way with the scene of the crime to be punished for the crime which they did not commit. In my work on that particular case, we discovered that both Skyhorse and Mohawk had FBI files going back at least 7 or 8 years, covering everything they've done in their lives, where they've given speeches, what articles they'd written, who they lived with, what they did. It followed Mohawk back to his childhood in New York State. It went back to Skyhorse's organizing of the Illinois AIM chapter in 1973, Skyhorse's participation in the insurrection at Wounded Knee in 73. And in fact, when you analyze FBI documents, which is something that I've been doing for a number of years, by their numbers and by the code used on the documents, you could tell whether or not the work being done against the so-called criminal individual is actually legal criminal investigation, or is, on the other hand, political, and therefore not within the legal jurisdiction of the intelligence community. The FBI is split into 2 sections in terms of their investigations. One part is the General Investigations Division, and the other one is the Domestic Intelligence Division. Most of domestic intelligence is not supposed to be going on. It has to do with just political activities. Something that the FBI has been doing since the 20s, since the 30s, since the Palmer raids, since they were used against unions, later used against populist farm groups, against anybody that the federal government thought was any kind of threat. Now, within the Domestic Intelligence Division, there's an Internal Security Branch, Section 2, and within that there is a Section 157, which is Indian, Spanish surnamed, and black radicals. And underneath that on their schematic diagram is a Section 170, which are the informants and provocateurs used in Section 157. We found that all of Skyhorse and Mohawk's files were listed as 157s, as opposed to the sections of the FBI which take care of criminal work. And that gave us our first evidence that this was not a criminal case, but in fact was a political prosecution. Now one has to ask, why does the FBI go to this kind of trouble? The murder occurred in October of 1974, during a time in which about 350 AIM people and supporters were being tried throughout the Midwest for Wounded Knee. In fact, just 1 month before the murder of George Aird, the Means-Banks case was thrown out in St. Paul. All 20 felony charges were thrown out of court by a judge who had been The chairman of the Americanism Committee of the South Dakota American Legion, Judge Fred Nickel, he threw out all 20 felony charges because of the FBI's falsification of evidence, their suborning perjury on the witness stand, of their manipulation of witnesses, just generally doing all the things that, for instance, Jimmy Carter complains that the Russians do in their court system. The FBI took a very bad beating in the press. Their image was very badly tarnished after the Means Banks trial, and also after the fact that of 600 people arrested at Wounded Knee, less than 7 were ever convicted of anything, and not a single person ever spent any time in prison for participating in Wounded Knee, for being convicted of anything during Wounded Knee. Most of the money which was coming to the defense lawyers and the defense teams in the Midwest to fight the Wounded Knee cases did not come from the Midwest, but came from the liberal and affluent populations of the Northeast and of the West Coast. One of the places we got a great deal of money from was the Los Angeles area. LA is the largest urban Indian community in the country and also has a very wealthy liberal community. As soon as Skyhorse and Mohawk were charged with a murder and a torture, and the LA Times and the other press played it up as an Indian ritual killing of a white man, that they said he was scalped, castrated, hung, none of which occurred. We traced all these false stories to the Sheriff's Department in Ventura County. But they accomplished what they set out to do. As soon as Skyhorse and Mohawk were charged and the press was manipulated, our funds from the Los Angeles area died. Were cut about 99%. At the time, I was working in Rapid City, South Dakota, and I, in fact, was doing the financial books. And our resources dried up. We're talking about the government having unlimited resources to try Indian people at that time in 6 different places throughout the Midwest at the same time, and we were trying to keep up with that. And that basically, in my mind, was the goal of the prosecution of Skyhorse and Mohawk. As I said, after 3.5 years of being in court and 4 years of Skyhorse and Mohawk being in prison, we eventually won. The jury took 1 vote, and they were unanimous on the first balloting. And in fact, I've interviewed some of the jurors from that case, and they all said that not only was there no evidence against the defendants, but it did bother them that through the trial, through the evidence, they were able to learn that the FBI was somewhat involved, although the judge and the U.S. attorney and the FBI agents who were subpoenaed to that case all refused to tell what they were doing. Now, we find this is part of a continual pattern of what the FBI has been doing to the American Indian movement throughout the country, whether it's in the Northwest, where the struggle is around the fishing rights in the waterways, or in the New York area or the Maine, where the struggle is around timber and land control, or in the Navajo area, where the struggle is against the polluting energy resource corporations coming in and taking Indian land. Where the American Indian movement is an organization of both young and old Indian people who want Indian people to have control of Indian land. They want to go back to all the valid treaties, all 380 some odd treaties signed between the United States and Indian tribes, which under international law and under the U.S. Constitution are still valid treaties. The United States has broken every single one of them and continues to this day to break all of them. AIM is trying to regain the control of the land so that Indian people can keep the resources that's on their land. We have to realize that today, with the so-called energy crisis, most of the usable shale oil, coal, uranium, a great deal of the fishing areas, the timber areas of the United States are on Indian reservations, are on land which are legally and morally Indian-controlled land. The job of the FBI, as it has been in the past against other organizations and other movements, is to make it easy for the multinational corporations who, in effect, through their financial contributions, control the Republican and Democratic parties, to be able, at the least cost to themselves, plunder the resources on Indian land. And what's stopping the FBI from allowing Kennecott Copper, Peabody Coal, and these corporations from coming into Indian land is the American Indian movement and their belief that land is sacred, that there's a responsibility to leave the earth in a better condition than it was when a person comes into the world, that the earth should be treated as sacred, that there's a responsibility to have the earth for future generations. Whereas multinational corporations have the ethic of profit, of getting as much money out of the resources as possible, regardless of how badly damaged the land is after they're finished with their work. Part of the FBI's campaigns against AIM include the area that I'm involved in because I'm an attorney, which is the politically motivated prosecutions of activist Indians. There hasn't been that much news in the last few months. Things are extremely quiet. A lot of the famous cases involving Indian people are now in appeal. But just as examples, in cases in different parts of the country, I'll mention a few cases, a few activists who are caught up in the judicial system. For instance, in Washington state, there is a woman named Yvonne Wanrow who 6 years ago shot a drunk man who was about to sexually molest her infant child, a man who had been convicted of a number of sexual incidents against children in that part of the state. She tried to stop him. She, at the time, Yvonne is about 5 feet tall. She's a very small woman at the time, had a broken leg with a cast up to her hip, and this man, about 230 pounds drunk, comes into her house and attacks her and her children. She killed the man in self-defense. State of Washington tried her and found her guilty of murder. She had the conviction overturned, and at this point the Supreme Court of the state of Washington is deciding whether or not to retry her for defending her children. One of the reasons that the state has been going after her for 6 years is because of her active participation in the Indian movement in the state of Washington. My belief is that if a white woman had done the same thing to an intruder who was about to molest her children, that woman would have been congratulated for doing what any other person would have done, which is protect their family. In another case up in South Dakota, where I used to practice, there's a man named Dick Marshall who was an AIM organizer in Pine Ridge. Dick is now serving a life sentence at hard labor for murder. He and Russell Means were charged with killing a man in a barroom brawl, a man who on his deathbed told the police that Marshall and Means did not do it, and he later died. Marshall and Means were tried separately. Russell was acquitted, and Dick Marshall was not. We find that the basic information for the prosecution in that case came from a woman by the name of Myrtle Poorbear, who has since recanted her testimony, has said in affidavits and in court, and in fact is now saying in the appeal of Dick Marshall's case, that the FBI threatened to kill her, as they had another woman, Anna Mae Aquash. They threatened her, they tried to pay her, they tried to bribe her, they tried to threaten her family in order to get her to be a snitch, an informant, and they were in fact successful in her case, in Dick Marshall's case. That trial, that conviction is also on appeal now. Moving up is another example to New York State. People remember the uprising in Attica in the early 70s. I believe it was 1972. The only person presently in prison in New York State for anything having to do with the Attica riot, even though hundreds of troopers, state troopers and militiamen were attacked by the McKay Commission as being extremely violent and vicious and sadistic in their takeover of the prison, and in fact, despite a number of convictions of inmates for alleged crimes, only one person, John Hill, is serving any time in New York State for Attica. He is a Mohawk Indian. He's the only person in prison for any participation in Attica. And I could go on and on all over the country about individual cases of AIM people, Indian activists being framed, caught up in this kind of system. People remember back in, I guess it was 2 summers ago, there was a case called Butler-Robidoux case in Cedar Rapids, Iowa. I was one of the attorneys on that case where 4 AIM activists were charged with killing 2 FBI agents, Agents Calder and Williams, during a shootout at Pine Ridge Reservation in 1975, June 26, 75. That trial again lasted a very long time. The government spent millions of dollars, had about 270 full-time FBI agents and 7 U.S. attorneys working on the prosecution. They indicted 4 AIM people: Dino Butler, Bob Robidoux, Jimmy Eagle, and Leonard Pelletier. Again, these AIM activists are taken off the reservation, are taken out of their homes, and prevented from continuing their political work by being brought into court and having to sit through court processes for a number of years. Even if they're not convicted, the government obtains its goal of putting people out of commission. And what happened to those 4 people? The Butler-Robidoux case, 2 of the men were tried in Cedar Rapids. We got a full acquittal in an all-white Iowa jury on the basis of our proof that the FBI, for the first time, we were able to prove on paper by using the FBI's own documents that they had a campaign to neutralize and destroy the American Indian movement. And as part of that campaign was a heavy program of provocateurs, of trying to incite violence on reservations. Most of the time that doesn't make news because the only people who die because of the provocation are Indian people. In this instance, when the FBI agents attacked this particular camp on the reservation, 2 of the agents and 1 Indian man were killed. And again, the press came out and said the agents begged for their lives, and they were shot with machine guns and scalped and castrated, and they begged, and they said some of their best friends are Indians and what have you. At trial, we proved that all of this press was false. It was put out by the FBI's propaganda minister, a man named Tom Cole, whose job is only to manipulate and control the press, and he does a very good job of it. Because of the inflammatory press, we had the trial moved from South Dakota to Iowa. The Iowa jury, after a long trial, understood what it meant to be attacked on the reservation by FBI agents. And they understood and accepted our defense that these Indian people were firing back in self-defense, protecting their community and their children from an attack. And much to our surprise, a group of 12 middle-aged, middle-class white Iowa citizens were able to accept the fact that FBI agents are not the people you see in the Ephraim Zimbalist Jr. show, but are in fact very close to being America's Gestapo. In that case, they did a typical prosecution. I mentioned before Anna Mae Aquash, who was one of our defense witnesses. She was killed at either by or at the behest of the FBI, February of 1975. 76. It's an interesting case in that the FBI found her body, cut off her hands and fingers, sent them to Washington, D.C., buried her under a false name at Pine Ridge Reservation, had a doctor from Nebraska list on the autopsy sheet that Anna Mae had died of exposure. We brought the body up because we didn't believe that. The weather had been very mild on the reservation that year. We brought the body up, and she had a gaping hole behind her left ear, and we had the medical examiner for St. Paul come in and examine the body. He said that she was shot at point-blank range, the back of her head, by either a .32 or a .38. To this day, the FBI, who of course we feel was part of the murder of Anna Mae, maintains that they don't know who did it. They won't comment on the case. They won't respond to Freedom of Information Act suits because their excuse is that the case is still under investigation, even though they have no clues, no suspects. We have a good idea, and people on the reservation believe that they know why the FBI can't come up with anything, because they probably know who did it and are protecting that individual or individuals. Again, like most AIM trials, the attorneys were followed. There were wiretaps, there were burglaries of our offices, there were infiltrators put into our law offices. In fact, at one point, the FBI attacked my office in Rapid City, 8 of the agents, and tried to go through our files without any warrants. Unfortunately, it's a very common thing to suspend the Constitution on Indian land and reservations. No one ever hears about it. There's no outrage. There's no press coverage. There's no protection by liberals or by politicians. Things that would not happen in downtown Columbia happen every day in places like Pine Ridge. Indian people are hauled through the system, are interrogated at gunpoint very often, their relatives are threatened, their families are threatened, and so on. To back up a little bit, the 4 Indian people who were charged with killing the 2 agents, Butler and Robidoux, were acquitted. Jimmy Eagle, after spending 15 months in prison, this is a 20-year-old man, was let go without being charged because the government, after 15 months, admitted there was never any evidence. And in fact, Jimmy's grandmother, a woman by the name of Gladys Bissonette, is one of the organizers of AIM on Pine Ridge Reservation, and my belief is that they kept Jimmy in jail to get after her, to see if she would tell them what they wanted to know about the deaths of the agents. Of course, she would not do it. Jimmy would not cooperate with them. They kept him in jail more than a year and then released him. The government started to panic. They were losing all of these cases, so their last chance was to get a man named Leonard Peltier. Leonard was tried in Fargo, North Dakota, in one of the most rigged, racist trials I've ever heard of. Again, the only witness against him was Myrtle Pourbear, who at trial, the defense tried to introduce her as a witness to say she was told that if she did not cooperate and lie for the FBI, that she would end up like Anna Mae. She came forward to us and said that she had lied against Leonard, that she had told the FBI that she watched him kill the agents, when in fact she was not even in South Dakota at the time of the deaths. And she said that she had been offered by the FBI a free one-way trip to Hawaii so that we could not find her to interview her during the trial, and so on and so forth. That kind of story came out. The judge in North Dakota refused to let us put any evidence on as to any frame-up, of any perjury, of any manipulation of witnesses, and in fact of any recantation of testimony by the only eyewitness, Myrtle Pourbear. Again, that case has been appealed to the 8th Circuit, which sits in St. Louis. Unfortunately, it was appealed to a panel of 3 judges, one of whom, lo and behold, in the middle of the appeal, Judge Webster was made the new head of the FBI. We tried to get a new panel of 3 judges to rehear the appeal. That was denied, so what we're now doing is waiting for a decision by 1 new judge and 2 judges who deliberated on the appeal with the new head of the FBI on a case where a man is charged and convicted of killing 2 FBI agents. And today, Leonard Peltier is in Marion Federal Pen, serving 2 life sentences for murders for alleged murders which he did not commit. I could go on, and in fact, I assume that people who have not heard about these things are not apt to believe them, hearing them from me. I would encourage people to get involved a little bit more and see things. We always encourage people to go to court, for instance. When we had people in Los Angeles coming to the Skyhorse Mohawk court, they could not believe what they saw. And they understood what we were talking about when they came into court, saw that Skyhorse and Mohawk often came to court bleeding from beatings of deputies. They came to a courtroom that was split in half by a bulletproof glass shield separating the lawyers and the defendants from the rest of the courtroom. They saw an insane judge who has now been thrown out of office, who is no longer a judge, yelling and screaming at the lawyers and the defendants, coddling and cooperating with the DA. And we encourage people that if trials of AIM people do occur in this part of the country, that they should go and see for themselves the kind of travesty of justice that their tax money is going to. I would suggest 2 things for people who are interested in the Indian movement, not only in the section of the movement involved in political prisoners and political repression, but in all aspects of the Indian movement. One thing people can do is write to an international Indian newspaper called Akwesasne Notes, which they can subscribe to at any amount of money they can afford. That's spelled Akwesasne, Akwesasne Notes. The address is Mohawk Nation, via Roosevelt Town, New York. Roosevelt Town is ROOSEVELTOWN. The zip is 13683. Akwesasne Notes comes out 6 or 8 times a year, has comprehensive coverage of the Indian movement in North, South, and Central America. One other thing I would mention to people is they might also follow up in contacting some of the organizations and smaller regional newsletters that are often advertised in Akwesasne Notes. One campaign going on in this part of the country right now is to get Russell Means out of the South Dakota State Pen. Russell, everybody knows, he's been an Indian leader for many, many years. He's been tried 7, 8, 9, 10 times for major felonies and never convicted. He's been shot in assassination attempts at least 6, 7 times. No one's ever been picked up or tried for shooting Russell, even though very often the people are identified, whether they're BIA, Bureau of Indian Affairs officials, police, what have you. Russell is serving 4 years in the state pen for what is called the Sioux Falls courthouse riot, a case in which during an AIM trial in Sioux Falls, South Dakota, the Judge Bottom, went to 2 of the court observers that the AIM had brought in, 2 clergymen from Colorado. I believe one was an archbishop. Well, I'm not sure what his status in the church was, but he was a high clergyman. The judge says to these 2 individuals, "I think you should not be in court today, there's going to be trouble." And the 2 clergymen refused. What happened was, when the judge walked in the afternoon session of court, he had the tactical police squad waiting in the wings. The spectators refused to stand for him, as is their right not to stand for judges they do not respect. He got extremely angry, said that they must stand or they'd be removed. The spectators refused. The tac squad came in and beat everybody in court, including spectators. They tear gassed the courtroom, they beat people with clubs and what have you. And of course, a number of AIM people were tried, were brought up on charges of causing this so-called riot. Most of those cases were dismissed because the judge found that they could not find 12 people in the state of South Dakota who did not believe that there was a possibility that they were innocent until proven guilty. So 8 of the people were immediately dismissed for lack of being able to find an unbiased jury in the state of South Dakota. When Russell came up on these charges, the court went through twice as many prospective jurors as they had in the previous cases and refused to dismiss, even though there wasn't a single person out of hundreds who did not think Russell was guilty of anything he was charged with, regardless of the evidence. In fact, the very charge that Russell is now serving time for, which is some ambiguous statute called conspiracy to riot to obstruct justice. He's the only person ever convicted of that charge in South Dakota. After he was convicted, the statute was thrown out as being unconstitutional, is no longer a law. Russell is now protesting his phony trial, his lack of fair trial, his conviction by a racist South Dakota jury. He's been on a hunger strike now for more than 2.5 weeks. He's very weak. He's already gotten the legal papers signed that he is not to be force-fed if he goes into a coma, and that he is now appealing to have the case removed from state court to federal court so that the federal issues of fair trial can be fully aired. The state Supreme Court of South Dakota is refusing to hear any constitutional issues on appeal. What I ask people to do if they're interested is not only to find out more about the case, but also, when they're convinced of the righteousness of Russell's position, is that we are writing letters to the federal judge Fred Nickel in the Sioux Falls District Court, Sioux Falls, South Dakota, asking him to release Russell pending the appeal of the federal issues so that Russell does not die in jail from his hunger protest. And we ask people to wire or call or write letters to Federal District Court Judge Fred Nickel in Sioux Falls, South Dakota, the U.S. District Courthouse, as fast as possible so that we can have Russell out, so we can have all the legal issues fully aired in federal court so that some semblance of justice can be had without killing Russell. And that, as a quick overview, are some of the things going on with with the Indian movement, with the Indian leadership in this country. We ask non-Indian people who hear this broadcast to attempt to learn more and participate, not only for the fact that it's a travesty. What happens to Indian people in this country is just a continuation without stop of what's happened for 300-400 years of genocide, but also the fact that if the government and the FBI gets away with doing what they do to the Indian movement, they're also going to do it to the rest of us. These are similar tactics they used against the anti-war movement, the student movement, the Chicano movement, the black movement, the women's movement, the labor unions, where they will infiltrate, they will provoke violence, they will frame people, throw them in jail, and so on and so forth. It doesn't begin and doesn't end with the Indian movement. And people have to realize that there's a common enemy in the FBI, that these people are thugs, they're criminals, they get away with murder, literally, and everything else that they do. And if they, again, get away with doing it to the American Indian movement, they'll be doing it to the rest of us. And people need to get involved to stop that.
Thanks a lot, Jack. I hope the message gets heard well.
Thank you for having me here.
Okay.
You've been listening to Jack Schwartz, lawyer for the American Indian Movement, recorded by Luke Lundemo at KOPN in Columbia, Missouri, on August 27th, 1978. The tape is being distributed by the program service of the National Federation of Community Broadcasters.